Medical cannabis and retail hemp are often discussed as if they are the same thing in Virginia. They are not. Confusion between these two categories has led to consumer risk, business violations, and enforcement challenges. Today, we are breaking down the legal difference between medical cannabis and retail hemp under Virginia law, how each is regulated, and why misunderstanding this distinction can carry real legal consequences. Here's the context and why this confusion exists. Virginia's cannabis laws have changed rapidly. As medical cannabis expanded and hemp-derived products became widely available in retail stores, many people assumed both operate under the same legal framework. They do not. Medical cannabis is governed by a tightly controlled medical program. Retail hemp products operate under a completely different statutory structure, with different oversight, testing requirements, and enforcement standards. This video is an educational, legal analysis of how Virginia law separates these two categories. Here's the legal foundation and two separate statutory systems. Medical cannabis in Virginia is regulated primarily under Title 54.1 and Title 4.1 of the Virginia Code. It is overseen by the Virginia Board of Pharmacy and requires participation in the state medical cannabis program. Retail hemp products are governed under Virginia's hemp laws, federal Farm Bill provisions, and state consumer protection rules. Oversight may involve the Department of Agriculture, consumer protection agencies, and local enforcement. The key point is this: medical cannabis and retail hemp are legally distinct systems. What qualifies as medical cannabis in Virginia? Medical cannabis refers to cannabis products dispensed through state-licensed medical cannabis dispensaries. These products are available only to registered patients with valid certifications. Medical cannabis products must meet strict requirements related to sourcing, formulation, labeling, testing, and dispensing. Every step is regulated. Patients are entered into a state system, products are tracked, and dispensaries operate under direct regulatory supervision. What retail hemp actually is. Retail hemp products are derived from hemp plants that meet federal and state definitions related to THC concentration. These products are often sold in convenience stores, smoke shops, wellness stores, or online. However, legality does not depend on availability. Retail hemp legality depends on formulation, THC levels, labeling accuracy, testing documentation, and marketing practices. Many products sold as hemp do not meet Virginia's regulatory standards. Key legal differences that matter. Medical cannabis products are approved, tracked, and dispensed through a closed medical system. Retail hemp products exist in an open commercial market with variable compliance. Medical cannabis products are intended for registered patients. Retail hemp products are consumer goods but must still comply with strict laws. The difference affects possession, enforcement, and legal risk. Who this affects. Consumers often assume that if a product is sold openly, it must be legal. That assumption is incorrect. Legality depends on compliance, not availability. Consumers who misunderstand this distinction may unknowingly possess products that fall outside Virginia's legal framework. This is especially true with vape products, concentrates, and high-potency items. Who else this affects? Well, small businesses are directly impacted by this confusion. Retailers often rely on distributor assurances, outdated guidance, or online claims. Laws change faster than education, and many businesses operate in good faith while unknowingly violating regulations. This creates enforcement risk, financial loss, and potential penalties. Here's a scenario. Imagine a Norfolk resident purchases a vape product labeled as hemp-derived from a local store. The product exceeds allowable thresholds or lacks proper testing documentation. From a legal perspective, the label does not protect the consumer or the retailer. Both may face legal exposure depending on enforcement circumstances. This scenario happens more often than many realize. Let's talk about the enforcement and compliance implications. Law enforcement, regulators, and courts must navigate these distinctions carefully. Medical cannabis protections do not automatically apply to retail hemp products. Retail hemp products that resemble medical cannabis in form or potency may face heightened scrutiny. This makes compliance documentation critical. Why this matters for Virginia communities. Understanding the difference between medical cannabis and retail hemp protects consumers, businesses, and communities. It reduces misinformation. It limits unintentional violations. It clarifies rights and responsibilities under Virginia law. This is not about promotion. It is about legal clarity. What to watch next? Virginia cannabis law continues to evolve through legislation, regulation, and court interpretation. Future videos will examine enforcement trends, testing standards, labeling rules, and compliance risks. For deeper analysis, we publish full legal breakdowns and host community discussions through the Norfolk City Cannabis Community. Question: do you think Virginia should do more to clearly separate medical cannabis from retail hemp in public education and enforcement guidance? Put your answer in the comments. Please like, comment, and subscribe for more videos like this focused on Virginia cannabis law and compliance.